Good morning, everyone. I want to welcome you to our workshop series here at STAC at the SBDC is giving. There are many people to thank who made this possible. I want to thank my staff, the STAC people, and I also have to thank Senator Schumer, who gave us an endorsement that gave us a portability grant, and we are now able to give this information out to you. You're going to be given information by a very experienced patent lawyer. You're also going to be given information by our senior business counsel, Lita. But all these experts that are being shown here and presenting here, they are here for you. You are the most important people. Our clients are the most important people. I would like you to engage. I would like you to ask questions. And I also want you to know this is a perfectly doable process. Getting a patent, creating a product, and selling it. And if you have any questions or need any further assistance, the SBDC of the Lower Hudson Valley is here. Now I'd like to introduce our guest speaker, Jack Schwartz.
Hi, everyone. My name's Jack Schwartz. I'm an attorney. I focus my practice on intellectual property law. I've been practicing for about over 30 years, specializing in patents, trademarks. I also do copyright work and some trade secret work. I'm also of counsel to a firm up in the Lower Hudson Valley called Adwar Ivco. And I'll be discussing intellectual property law, patents, trademarks, copyrights, and trade secrets with you. So initially, what is intellectual property law? Most people really don't have much information on it or very unfamiliar with it, mix up the terms quite a bit. I'm here to help you understand that and to explain it to you in some way. IP rights or intellectual property rights are creative works or ideas embodied in a form that can be shared or enable others to recreate, emulate, and reproduce. What that means is when you come up with an idea, you create something, you can obtain protection for that, and the government gives you that protection as an incentive for you to share that information with the public. Now, our IP rights are defined by both statutory law and by common laws. Some rights you get in IP law for just using your intellectual property. Others are protected by certain laws and regulations that the government has created. There are 4 types of intellectual property law, and I'll be discussing all 4 of them. There's patents, trademarks, copyrights, and trade secrets. Now, first I'll discuss patents. Okay, what is a patent? A patent is essentially a government right which, when you come up with an invention, you create something, you have an idea, you get a patent on it, the government gives you protection for that. And what that allows you to do is to prevent other people from making, using, offering for sale, or selling your invention, or importing a device embodying your invention. It does not necessarily grant you the right to make, use, offer for sale, or import your invention. That is because some people come up with inventions that may not be legal or may be protected by the government in some way. So it allows you to at least stop other people from doing that. Now, US patents are effective only inside the United States. If you want protection or patent protection for your invention in other countries, there are a number of ways that you can go about getting that protection. One is to file individually in each country. In that instance, you'd consult a patent attorney, and he would work with an associate in the foreign country to obtain a patent for you there. The process, they're varied throughout each country, but generally similar. If you file a US patent, you can then Actually, you'd have essentially 1 year in most countries to then file in any foreign country and go through the process of obtaining a patent in that country. You can also file what's called an international patent or through what's called the Patent Cooperation Treaty, which is an agreement between the United States and about 140-something other countries. Through that process, you can file a single application with what's called the International Bureau, and then you go through a 30-month process there where the application is reviewed and examined, and you get some sort of at least initial determination. At the end of that process, you then have to know which individual countries you'd want to file for protection in and file individually in each of those countries. But it's a process that gives you about 30 months to decide whether you want to file in any other countries. Now, what can be patented? What can be patented is any new and useful process, machine, manufacture, composition of matter, or any new or useful improvement of any of the above. Laws of nature, physical phenomena, what's considered abstract ideas, or an idea or suggestion, you can't get a patent on those things. Subject matter that can be patented are it's a wide variety of things that fall under that criteria there. You can even patent if you have a method of doing business. There are ways of getting patents on that and protection for those. Now, there are 3 types of patents. One you're probably most familiar with is utility patents. And that would provide exclusive rights for a specified time for any new and useful process, machine, article of manufacture, composition of matter. That covers a wide variety of items. It can be a device, it can be a method, it could be a combination of both. And for utility patents, if you have an invention, you're not sure whether it's patentable or not, you need to take some time to see if you can go and develop the invention. You can file what's called a provisional patent application. What that does is it essentially gives you a filing date for your patent application. The United States is what's called a first-to-file country, which means the first person to file an application on an invention is entitled to a patent for that invention. Now, if you file a provisional application, you get that filing date. So as long as you have that filing date, nobody who files an application for your invention after that date, you have prior rights. Now, within what a provisional patent application does, it's a 12-month period in which you have to go and develop your invention and then prepare and file what's called a non-provisional application. The non-provisional application is the application that gets examined by the patent office and hopefully eventually issues into a patent. Provisional application, it sits in the patent office, nobody looks at it, nobody knows about it unless you tell them about it, and it sits there for 1 year. If you do nothing, in 1 year, it expires and goes away. If you file your non-provisional application within that year, that application will then go ahead and be examined by the patent office. There's also what's called design patent applications or design patents. That would cover any new, original, and ornamental design. Say you come up with a telephone that looks like a banana. You can then patent that, and that would cover what that phone looks like. And nobody else, if you get a patent on that, would be able to produce a phone that looks like a banana. And you get exclusive rights to that design for a certain period of time. Now, there's also what's known as plant patents. And plant patents are exclusive rights you'd get for any discovered or asexually produced reproduce distinct variety of plant. Say you splice two plants together and it comes up with a new version of that plant, that you can get protection for that plant. Now, how long is a patent valid? For utility and plant patents, you get up to 20 years from the date of filing of your first non-provisional application. Utility patent, in order to keep that in force for the entire term, you have to pay maintenance fees periodically to the patent office. Now, under certain circumstances for utility patents, you can extend that period if issues arise in the patent office and the patent office takes longer than the expected time or their required time to respond to office actions, if you have to go through an appeal with the patent office. Those delays in prosecution can be added on to the patent term at the end of the patent term. The patent office, once your patent issues, the patent office figures out that amount of time and notifies you of how much patent term extension you'll get. All of that is because the period of the term that you're entitled to patent protection for starts from the day that you file the application. So if it takes an exorbitant time to go through the patent office compensates you for that time. A design patent, on the other hand, extends for 15 years from the day that the patent is granted. So it doesn't matter what day you file it. The day that the patent grants, that the patent office says you're entitled to a patent and the patent issues, you have 15 years from that date for protection of that design. For a design patent, unlike a utility patent, you don't need to pay any maintenance fees once the patent issues. Okay, who may apply for a patent? In the United States, you must name all inventors on a patent application. So any inventor or their legal representative, with certain exceptions, can apply for a patent. Exceptions are when an inventor has died, is legally incapacitated, refuses to apply, or cannot be found, if the inventor has assigned the rights or is obligated to assign the rights to someone, the person who the rights are assigned to or has an obligation to receive those rights can apply for the patent. Now, there's not always one inventor for a patent. In many instances, there may be multiple inventors. Now, those people can apply together as co-inventors. It's important, if you have co-inventors, that you name all co-inventors on a patent application. You don't want issues that come up at a later date where someone comes and sees that you received a patent and says, hey, I helped you with that patent. I should be a co-inventor and I'm entitled to some rights. So you make sure that all inventors are listed on the patent application. Now, another person who can apply for a patent is anyone whom the invention was assigned or who the inventor is obligated to assign can apply for a patent as the applicant for that patent. Now, only people who have made contributions to the invention can apply for a patent as well. If you've not made a contribution, you should not be named as an inventor. And if you've not been assigned the rights to the patent, you cannot apply for the patent. Now, if you inherit an invention, say the inventor died and left you in their will that invention, you can apply for a patent as an applicant. However, if you're an employee of the United States Patent and Trademark Office, you're not allowed to apply for a patent application unless you've inherited it. Now, there's no requirement that you be a U.S. citizen to apply for a patent. Anyone who's an inventor can apply, and regardless of your citizenship. Okay, now the general patent process goes in this manner. The first thing you should do when you come up with an invention is perform a patent search. At that point, you want to decide, should I file a provisional application? get my filing date and go and further develop the invention, or possibly even look for investors. Many things you can do during that 1-year period, or you can just go straight and file for a non-provisional application. Uh, Once you filed for your non-provisional application, unless certain circumstances where you request non-publication, your patent application will be patent published 18 months after you file, and your application will then be considered public information. Uh, At that point, the patent application will be assigned to an examiner, and the application will be examined. And you'll go through all the procedures for examination of the patent application, which I'll be discussing. Now, before applying for a patent, it's highly recommended, it's not required, but definitely recommended to perform a patent search. Search will assist you in determining the state of the prior art, or what is known in that technological field, and whether there's commercial value in the process. Like I said, it's not required, but it's strongly recommended. The search should include not only should include all publications, including U.S. patents, published U.S. patent applications, foreign patents, published foreign patent applications, and also any available literature and publications. Because anything from the beginning of time that is public information is considered prior art and can be used to show that your invention may not be new and entitled to a patent. When you have a search performed, it's strongly recommended you have it performed by either a patent attorney or a patent agent. A patent agent is a person who has technical knowledge and has taken the necessary exams to be registered with the U.S. Patent Office. So they are familiar with the process, familiar with what is required in a patent or to obtain in a patent, and can adequately handle that. A patent attorney is essentially a patent agent who has also gone to law school and passed the bar exam. The patent attorney is thus able to do quite a bit more for you because they can handle all these legal aspects of any patent application or the process, whereas a patent agent can only act as your representative before the patent office. Now, provisional application, it's a quick, inexpensive way to establish a filing date for an invention that you'd eventually later file in a non-provisional application. Now, they're automatically abandoned by the patent office at 12 months after the filing date. They're not examined. Nobody ever looks at it. It gets filed in the patent office, gets a serial number, and gets stuck in a drawer somewhere. And nobody ever sees it. The corresponding non-provisional application must be filed within the 12-month period to benefit from the filing date of the provisional application. Now, provisional applications have many fewer requirements than a non-provisional application. There are no claims needed. There's no oath or declaration that needs to be filed by the inventor. There's no particular format. The only thing that you would want to make sure in your provisional application is that it fully discloses your invention in as much detail as possible. Because if you amend your application when you're preparing your non-provisional application to include information that's not in the provisional application, you may not be entitled to the filing date of the provisional for the new information that's in the non-provisional application that'll be examined. Okay, the next step would be filing your non-provisional application. There's certain requirements for the non-provisional application that you must follow. Specifically, you'd need a specification, which includes a detailed description of your invention, and an abstract, which is essentially a one-paragraph description of your invention. The detailed description needs to be in enough detail where it's what's called an enabling disclosure, where anyone who reads your patent application should be able to make your invention and use your invention. If you get a patent on it, they won't be able to do those things, but they should be able to based on your description. I I find the easiest way to explain it is it's a user manual for your invention. Uh, at the end of the patent application is a section that's called the claims. The claims are essentially what is protected by your patent. They'll define the scope of protection you receive from any patent. Uh, it needs to include all necessary elements of your invention and describe how those parts are connected, or the method, it needs to at least include all necessary steps in the method of your invention so that it would be operational and produce the result that you are looking for. Now, you'd also include drawings in your application. The drawings would be uh, essentially images of your invention that are used with your detailed description to describe your invention. You also need an oath or declaration signed by the inventors, which states that the inventor believes themselves to be the inventor of the application, that they have reviewed the application and the application adequately describes their invention. You also need to pay filing, search, and examination fees to the patent office when you file your application. And you also need to include what's called an application data sheet, which gives the information on all the inventors, any applicants that are that have acquired rights to the invention, includes any information on any priority documents, uh, and a number of other aspects that will be used in identifying your application. Now, all applications filed with the US Patent and Trademark Office must be in English. If they're not in English, then you need to file a translation of the application with when you file the non-provisional application. If you're represented by an attorney, you should file a power of attorney. And there are different fees based on certain criteria. The Patent Office separates their fees by large entities, which is large international corporations, small entities, and then there's micro entities, which could be individual inventors, and there are certain requirements for that, such as earnings, how much money you make. And if you're a micro entity, you're entitled to the lowest level of fees, which makes it a lot more palatable to file the application. And you need to file what's called a certification of microentity, asserting that you are a microentity. Now, one reason you might not file your application in English is if you're in a foreign country and you filed in a foreign country. Patent applications, uh, when you're filing, you need to determine if you want to file only in the United States or if you're interested in filing any foreign jurisdictions. You can file individually in every foreign country because the US patent application only covers or provides you protection in the United States. Or you could file what's called a patent cooperation treaty application, which is an application, what's commonly known as maybe an international patent application. It provides you a 30-month process where you can then determine which countries you want to extend protection of your application to. At the end of the 30-month process, which goes during that 30-month process, you go through an examination procedure and you get what's called a written opinion at the end. At that point, you need to decide which countries you want to file in, and you can file in any of the 140 or so countries that are members of the Patent Cooperation Treaty. Okay, next step is publication of your application after it's filed. Publication happens before a grant and 18 months after the earliest effective filing date of your patent application. Uh, Say you filed in a foreign country and then moved your application and filed in the United States based on that country, would be 18 months after what's called your priority date. If you filed directly in the United States, it would be 18 months after the non-provisional filing date. If you file a provisional application, that doesn't count as your effective filing date for purposes of publication. Uh, if you're only filing in the United States, you may want to consider filing a non-publication request. In that case, your application will remain confidential in the patent office. Nobody will be able to see it unless you tell them about it for the period that it's under examination or until the patent actually issues. But in order to do that, you need to make an attestation that you have no intention to file outside of the United States. If you can initially file a non-publication request, and if at a later date you decide you're going to file outside the United States, you then must withdraw your non-publication request. Okay, and once the application is published, it's considered public information and it's no longer held in confidence by the U.S. Patent and Trademark Office. At that point, anyone can get on the U.S. Patent and Trademark Office website and search up your patent application and see the entire file history to date of what went on in your application. Okay, next, the application gets examined. There is, within the patent office, it's divided among many technology centers. Now, each technology center deals with essentially a different technology. There covers the gamut of all technologies of devices, methods, everything that can be patented, and there are numerous different technology centers. Each technology center has a director and has a staff of examiners, all with knowledge of that particular technology. Those examiners will review the applications and determine whether a patent should be granted. Once your application's filed, it's assigned to an examiner, a particular examiner who you'll be dealing with through the entire patenting process. Now, that examiner will review the application, study it for compliance with all legal requirements, and then perform their own search of your invention. They'll go through all the patent files, U.S. patent applications that have been published, U.S. patents that have been granted, foreign patents, foreign patent applications that have been published, and all publications that are in the public domain. From that, they will determine whether your invention has been disclosed in another publication, or they would consider it obvious over a combination of of a number of different references, where maybe part of your invention is taught in one application or one publication. Another part of your invention could be taught in another publication. If the examiner looks and believes that those two publications, it would be obvious to combine them to make your invention, they can issue what's called an office action. Now, if the examiner goes through their search, they find no prior art that they think would affect the patentability of your invention, they'll issue what's called a notice of allowance. Once a notice of allowance is issued, you then have 3 months in order to pay an issue fee. And once you pay the issue fee, your patent application will be put in line for issuance and will eventually issue. If the examiner finds issues with the application, they may find issues with the legal requirements, that certain problems exist with your claims, that maybe there's distinctions, discrepancies between your drawings and the detailed description. Then they may also find prior art, like I said, that might show your invention. They'll issue what's called an office action. In that office action, they'll explain all the issues, and make rejections or objections to your application. Now, at that point, you have the opportunity to respond to the patent office. You're dealing with the patent office is essentially a negotiation to see what you're entitled to in terms of a patent and if you're entitled to a patent. Now, in response to that office action, you can make amendments to your claims. Uh, you can at some point make, if necessary, amendments to your drawings in the app and the specification. You can't add new matter to your application once it's filed. So you have to be very careful if you're making amendments to the specification or to the drawings. Now, you can amend your claims. You can also argue over the examiner's rejections and explain why you believe the examiner is incorrect. Maybe they misinterpreted a reference. Maybe they misinterpreted your invention. You explain that to the examiner and you file a response to that office action. Now, if your amendments and your arguments that you present to the examiner in that response to the office action convinces the examiner you're entitled to a patent, they'll also issue a notice of allowance. And then once you pay your issue fee, you'll receive a patent. If they're not convinced by your amendments and your arguments, the examiner can then issue what's called a further or a final office action. Now, you'll also have the opportunity to respond to that office action. With the patent office, at least the US Patent Office, this process can continue on for essentially the patent term, or 20 years from the filing date, if necessary, and if you have the desire to go through all of that. Now, if you receive a final office action, you can file a response to the final office action, but if you do not overcome the objections and rejections to the examiner has made in that final office action, you can then request what's called a request for continued examination, or you can appeal. If you think there's still room to discuss with the examiner and there's some room where you think you can come to some agreement with the examiner, it's usually best to file a request for continued examination. It's also possible to discuss this personally with the examiner. You set up an interview with the examiner, and maybe a lot of times that works to your advantage because it's a lot easier to explain things when you're talking to somebody than it is to try and convince them in writing. If you don't believe you can convince the examiner or you're at an impasse with the examiner, you can file an appeal to the Patent Trial and Appeal Board. That gives you an opportunity to present your case to an independent board separate from the examiner and see if they would agree with your position and that you're entitled to a patent. Now, if your appeal's unsuccessful, you can then appeal to get into the regular court system and appeal to the Federal Circuit or the Court of Appeals for the Federal Circuit. And that's where you have to consider things because it starts to get really expensive at that point. Okay. Now, once the examiner determines the patent applications is entitled to issuance, you'll get a notice of allowance that indicates the allowed claims and possibly reasons why your patent was allowed. You then pay your issue fee, and once your issue fee is paid, your patent will issue in due course, hopefully. Once you have a patent, that's not the end of the process, at least with utility patents. Periodically, you have to pay what's called maintenance fees. It's the patent office asking for additional funds, essentially. And at 3.5 years, 7.5 years, and 11.5 years from the date the patent is granted, you then need to pay your issue fees to keep your patent in force for its full term. Okay, plant and design patents do not require maintenance fees. Once it's patented, you're entitled to the full term of that patent. Okay, and that's essentially patents, or at least the patenting process. Next, we'll discuss trademarks. What is a trademark? Trademark can be any word, phrase, symbol, design, sound, or combination of those things that identify goods or services. Trademark is used to distinguish goods and services from those of competitors. It also is mainly used to identify the source of the goods or the services. So when you see that trademark, you know where those goods or services are coming from, who's making them, who's performing them, and it goes along with a certain expected quality for those goods and services. Now, the term trademark can refer to both trademarks and service marks. Um, like I said, the trademark identifies the source of the goods or services. It provides legal protection for that brand and provides strong legal tools for guarding against counterfeiting and fraud. When people come and use your trademark without your permission, you have the means at that point to go and enforce your trademark against them, asserting that they're infringing your trademark. Now, owning a trademark does not provide you, if it's just a simple term or a term with a logo, it doesn't provide you rights to that term. It only gives you rights on how that word or phrase is used with the specific goods or services in your trademark or that your trademark identifies. Uh, Along those lines, you can't go and trademark the term chair for a chair. That would be considered descriptive, and not allowing anybody to use the term that's well known for that item is not permitted. Okay, now it's not necessary to file a trademark registration or file a trademark application and obtain a trademark registration to get rights associated with trademarks. You can obtain rights, what's called common law rights to trademarks, just by using the mark. Now, those rights are limited that you'd obtain just by using the mark and not filing an application, because they only would apply to the geographic area in which you're using the mark. Say you have goods that you only sell in the tri-state area. You can't then go and enforce a common law trademark against somebody who might be using that mark in California, where you have absolutely no connection. Now, in order to obtain stronger nationwide marks or rights, you would file a trademark application. And if you're granted a U.S. trademark registration, you would then obtain rights to that mark on the particular goods and services that may be listed in your registration for the entire U.S. Okay? Like I said, trademark registration isn't required, but a registered trademark provides you rights and protections greater than unregistered trademarks because it covers the United States. It's also gives you the presumption of validity once you receive a U.S. trademark registration. So, okay. Now, when you use a trademark or when you develop a trademark, if you do not have a U.S. registration, you should identify your trademark in some way to identify that you're using the mark as a trademark. To do that, I'm sure you've seen trademarks where there's a little TM or an SM next to the mark. That's identifying that somebody is using that mark as a trademark, but they do not have a U.S. registration. Once you get a U.S. registration, you can use the familiar R in a circle mark next to your trademark. That identifies that not only are you using that mark as a trademark, but you also have a U.S. trademark registration that was issued by the U.S. Patent and Trademark Office. But you can only use that on the goods and services that are listed in your trademark registration. Now, it's advisable to include that symbol so that people are aware that you're using it as a trademark and then don't go and use that mark for their own goods and services. they know that that mark, you're claiming ownership of that mark for those goods. Okay? Now, when you file a US trademark application, there's certain requirements and information that you need to provide to the trademark office. Uh, First is you need to identify the mark. If your mark is just a term, it's called a word mark, and there's no drawing required. If your mark is a logo, a combination of words and logo, uh, then you need to provide what's called a drawing page to the trademark office that shows the mark. You'll also need to provide a description of your logo, what it looks like, the words that are in your logo, and identifying information like that. You also need to identify the filing basis for your mark. Now, if you're using the mark, you'd be filing what's known as an in-use trademark application. Now, to file a US trademark application, there is no requirement that you first use the mark. So you can file what's called an intent to use trademark application. In that application, you must make an assertion that you do have an intention to use the mark at a later date. Now, you can file an application based on a foreign application or a foreign registration. There are certain treaties with the US which determines how you would file that application. But that's also possible if an application was filed in a foreign jurisdiction, and you're looking to also extend protection to the United States. Now, the trademark can be owned by an individual, it can be owned by a company, it can be owned by any number of different entities. You need to provide the name of the applicant, the address of the applicant, the entity type of the applicant, which can be, say, individual, corporation, partnership. You also need to indicate the citizenship of the applicant. Additionally, you also need to provide an applicant email address. This is a somewhat new requirement for trademark applications, and it's in response to the trademark office seeing quite a bit of fraudulent trademarks being filed. So they want to make sure that the applicant is a true entity and has at least an email address that they can be contacted on. Now, with the trademark application, you also have to provide a description of the goods and services that you want covered by by any eventual registration. The trademark office has what's called an ID manual, where they have acceptable acceptable descriptions for certain goods and services. You can also file what's known as free-form descriptions, where you make up your own description if nothing particularly within the ID manual adequately describes the goods or services that you want covered with your application. The difference between the two is if you use the pre-approved descriptions that the trademark office sets forth, you're entitled to reduced filing fees. And if you use your own description, the filing fees, the difference is it's $350 per class if you're filing using the approved descriptions. It's an additional $200 per class if you file using your own description that's not pre-approved. Now, if your mark is in use at the date that you file your application, you need to file what's called specimens of use, showing your use of your mark in commerce. You also need to provide your date of first use in the United States so that the trademark office has all of that information when you file. If you don't file that information at the time of filing, you'll eventually need to file that information before a registration will issue. You also need to pay the filing fees at that point. Now, similar to patents, trademark application is also assigned to a trademark examiner, who then does their own searching and review of your application. Now, as part of the examination, the examiner will search registered and pending trademarks. This will be limited to the US because trademark is only valid in the US. And they'll also search maybe common law, search on the internet for different marks that may be similar or confusing to yours. And they'll determine whether your mark is the standard is confusingly similar to other trademarks. Either the mark itself and the goods that they're used on. The trademark office will determine if they believe it's confusingly similar to your mark, and they have a prior date. They'll also search your application and make sure all formal requirements of your application are met. Certain things that they might look at is, say, like I mentioned before, if your mark is descriptive of the goods that you're using it on. There are other issues that may come up with respect to the actual mark you're using, and the trademark office will examine that also. Now, if you go through the examination procedure, if you get an office action and the examiner objects to certain issues in your trademark or makes certain refusals over other trademarks, you do have an opportunity to respond to that, and you have the opportunity to go and convince the examiner that you are entitled to registration, that your mark is not confusingly similar for whatever reason with any marks that they've cited, or you can also amend your application to take care of any formal requirements they find. Now, after your trademark application is approved, it's published in the online Trademark Official Gazette. What that does is it gives any member of the public who thinks that registration of your trademark will harm them in any way the opportunity to go and oppose the registration of your trademark. What they then do is they have a 30-day period to file what's called a notice of opposition with the Trademark Trial and Appeal Board. Now, if no opposition is filed and your application has been based on your prior use of the trademark will then proceed to register. If your application has not been used and you've only filed as an intent to use the mark, you'll get what's called a notice of allowance. You then have a period of time to file what's called a statement of use. With that statement of use, you'll need to submit specimens showing use of your mark and identify the date of first use of your mark. Now, no trademark will be allowed to issue based on intent to use unless you first used the mark. You have a 6-month period after you get your statement of use or after you get your notice of allowance to file your statement of use. If you still haven't used the mark in that 6 months, you then can file a request for extending that period. You can file up to 5 requests for extending that period. So once you get your notice of allowance, you have 3 years after that date to actually use your mark and show use to the trademark office. Now, once you show use and the use is approved, your mark will then proceed to register. Now, if you do file based on a foreign trademark registration, as I mentioned previously, for those applications, there's no requirement to show use in order to obtain a registration. If your mark is approved or your application is approved based on a foreign registration or application, you will be entitled to a registration without showing use. Eventually, you'll need to show use, but you do not need to get the initial registration. And once the trademark is registered, there are certain requirements to maintain the registration. Now, you can keep a trademark registration essentially forever. Once you get your registration, between 5 and 6 years after your registration issues, you need to file what's called a Section 8 Declaration of Continued Use. In order to maintain a trademark and keep your registration, you need to continually use the mark through its life. If you stop using it, essentially the term, it's around 3 years the trademark office sets forth. You've effectively abandoned your trademark if you've gone 3 years without using it. But between 5 and 6 years, you need to show continued use of the mark at that point. Then between 9 and 10 years, you need to file what's called a renewal application. And with the renewal application, you again have to show use of your mark and continued use and attest to that mark has been continually used over that period. After you file that, every 10 years after that, you then need to file another renewal application. You pay the requisite fees, and you can show that you've continually used the mark through that period. And this can go on forever, essentially. Okay, and that's trademarks. Now we'll look at copyrights. Now, what is a copyright? Copyright protects original works of authorship, including literary, dramatic, musical, artistic works, such as poetry, novels, movies, songs, computer software, architecture. It does not protect facts. It does not protect ideas or systems or methods of operation, which we've already discussed is what would be protected by patents. But it can protect the way those things are expressed. So copyright essentially protects your expressions. Now, a work is protected under copyright from the moment it's created and fixed in a tangible medium or a tangible form, directly or with the aid of a machine or a device. So you don't need to go and file for copyright registration in order to be entitled to copyright protection. Once you create that work and you fix it to a tangible medium, say you're writing a poem, when you write it down on paper or you type it on your computer, you have copyright protection, at least limited common law copyright protection. Now, registration is voluntary, but, and this is the important point, if somebody is infringing your copyright, you need to have a registration in order to enforce your copyright. You cannot enforce your copyright registration or any rights that you've obtained without first getting a registration. So I always suggest once you create a work, file an application with the Copyright Office. The filing fee is minimal. I believe it's about $55, and it's a 2-page form that needs to be filled out. I suggest you consult an attorney, but it's something that anybody can do. And it will help protect you and allow you to enforce. Now, in order to register a work, you just need to file a paper or online form. You get on the Copyright Office website and fill out the forms and pay the fees. Based on the different types of work, each different type of work, there's a different form with the Copyright Office you need to file. You can file works as collections, so you can pay one fee for multiple related works. There are different requirements for that. But those are things that if you're looking to register, you can investigate and figure out. Okay, there are certain reasons to register your work. First, many choose to register because they want the facts of their copyright on the public record. They want people to know. Now, one issue with copyright is if you create something and then somebody independently creates that without knowledge of what you've created, they're also entitled to a copyright on that work. Uh, it's not something where just because you created it that you're entitled to it. If somebody else also creates that same work, but independently of you, without any knowledge of you, in order to uh, accuse them of infringement, you have to show that they had some access to your work. Now, so you'd want your work on the public record so that at least there's some basis for arguing they had some knowledge of your work. It also enables you, like I said before, to bring a lawsuit against an infringer. Without that registration, you cannot file a copyright infringement suit against somebody. You first need to get that registration. And then registered works are also might be entitled to statutory damages or attorney fees. So the incentive to register your work as soon as possible enables you to collect larger damages if you get into litigation for infringement. Also, if registration is within 5 years of publication of your work, it's considered prima facie evidence in court that your registration is valid and you're entitled to that copyright. Okay, now, is US copyright valid in other countries? Well, yes, it may be. The United States has copyright relations with most countries in the world, and based on those agreements, all the countries that we have agreements with, there's there's reciprocity there. We give the rights to those citizens any copyrights, and then they also grant those rights to anyone who obtains a U.S. registration. Um, we don't have agreements with every country, though. So, in order to make sure your copyright is valid in other countries or will be enforced and respected in other countries, you need to go and research whether there's an agreement with that country. Okay, terms of copyrights. There are multiple factors for determining the term of a copyright, depending upon who created the work, when it was created, and a number of other issues. Now, whether it's been published. Now, if a work was created after January 1st, 1978, the term of that work is the life of the author of that work plus 70 years. So that author's estate or the author's people who've been maybe mentioned in the author's will, they'd be entitled to the benefits of that work for 70 years after the author dies. Now, if the work is an anonymous work, a pseudonymous work, or a work made for hire, the term would be 95 years from the date of the first publication, or 120 years from the year of creation, whichever expires first. So if you create a work and you don't sign it, but you do publish it, that work, you can obtain royalties, obtain any benefits of that work for 95 years from the day you publish it, or if it went unpublished for quite a number of years, 120 years from the date the work was created. If your work was published prior to 1978, there are a number of factors that can vary what the term is for that work. Okay, next topic is trade secrets. Now, trade secret is information that's either actual or potential independent economic value by virtue of not being generally known. It has value to others who can't legitimately obtain the information, and it's subject to reasonable efforts to maintain its secrecy. As an example, I think the most famous trade secret is the formula for Coca-Cola. That's been held forever, since the creation of Coke, and they've been profiting from that trade secret for longer than I've been alive. Now, in order to maintain a trade secret, you need to meet all three of those elements. And if any of those elements cease to exist, trade secret will also cease to exist. And there's no limit on the amount of time that a trade secret can be protected. It all depends on how long you can keep it secret and whether anybody can reverse engineer it. Now, that's in direct contrast to patent protection. Patent system was set up as an incentive for people to disclose their inventions. The reason you get patent protection is the government's giving you that protection in order to entice you to enlarge the technological knowledge of the world. Basically, share all your information with the world, and they'll grant you certain protections. Trade secret, on the other hand, is the complete opposite. You get protection based on how long you can keep your invention secret. Now, here, patents require a detailed and enabling disclosure about their invention in exchange for the right to exclude others from practicing that invention for a limited period of time. Now, once a patent expires, the information is no longer protected, and anybody can then practice your invention. But unlike trade secrets, patents protect against independent discovery. So with a patent, as long as your patent is valid, even if somebody without knowledge of your patent goes and invents the same device, you have the protection. You can stop them from practicing what they've just invented because you did it first. With trade secret, if you have a trade secret and somebody independently comes up with the same idea, you can't stop them from practicing their invention. So patent protection eliminates your need to maintain secrecy of your invention. But trade secrets are required to be maintained confidential and are protected as long as you keep them secret and absent any discovery by anyone else. That basically covers the four main aspects of intellectual property. And does anybody have any questions?
Question is, if you invent a new board game, do you need to patent it?
If you want protection, there may be ways to patent the board game. There are a number of different ways you can protect it. You can protect, firstly, by copyright, maybe how the board is designed and looks. You can possibly get a design patent on certain aspects of the invention. There may be ways to patent both the game and the method of playing the game. It's a bit of a general question, but there are numerous ways in which the board game can be protected.
How many provisional patents can you submit before it becomes a non-provisional patent? Could I keep doing it annually to protect my idea, or?
As long as you don't disclose your idea.
Okay.
You can file a provisional application, sit in the patent office for the year, it expires, you file another one.
On the same
on the same thing, but once you make it public, once you go and speak to somebody, disclose it to somebody, offer to sell it to somebody, it then becomes public information, and your provisional application would essentially, well, it would be useless.
Is it patentable
It can
still?
be. It depends on the timing.
Okay.
You have, in the United States, there's a 1-year grace period from the time you disclose your invention to when you must file up for patent protection. Outside the United States, in just about every other country, there's no grace period provided. So if you want protection outside the United States, you're out of luck. If you want it inside the United States, you'd need to file a patent application within that 1-year period.
Okay.
For a product, do you, before you actually build the product, do you patent or do you wait till you actually have something?
There's no requirement to have a prototype or working model of your invention before you file for patent protection. So you can, once you come up with the idea, as long as your invention doesn't defy the laws of physics, one thing the patent office specifically will reject immediately is what's called a perpetual motion machine, where it's essentially saying you're you're creating electricity or creating energy. As long as your invention, you give enough disclosure where your invention can be made and used, you can file for patent protection, and there's no reason or no requirement to have a working model.
And you have 12 months before you file then provisional?
If you file a provisional application. If you want to file a non-provisional, you can do that immediately. There's no requirement to file a provisional application. It's just a method that the patent office provides where it's a lot less expensive and it gives you a 1-year window to go and discuss your invention with other people, disclose your invention, maybe attempt to market it and see if it's feasible to go through with and move forward or worthwhile.
So that's the main reason to do provisional first, is just to make sure it's worthwhile.
That's one main reason that a lot of people use. Get your filing date, and then you can go and disclose it to others without worrying about whether you're starting the bar date running or preventing yourself from getting a patent outside the United States. And it's a lot cheaper to do that than to go straight into a non-provisional application. So it gives you a time to raise funds also.
I was told to direct the online questions up here so everybody can hear. The next online question from our virtual audience is, what are examples of first use for trademarks? Is the use on website, collateral materials, or use on social media classify as sufficient?
It can be. It needs to, well, firstly, if it's a logo, you need to actually use the logo that you're looking to get protected. And it also needs to be associated with the goods or services that you're seeking protection on. So it can, use on the internet, that's one use that would be shown as use throughout the United States. So like I said, if you're using your mark and you don't file for trademark protection or trademark application, you're restricted to the protection in the geographic region in which you use it. If it's used on the internet, then that would be considered use throughout the country. But it needs to be the same mark that you're looking to get protected and on the goods that you're associating the mark with.
Okay, and the feedback on that was, yes, it is a logo that is in question, so.
So you would need to use the exact same logo on the goods that would be protected by your trademark registration, and that should be considered good use. You have to use it in the proper way.
Okay, next question. What are some examples of patents and copyrights being abused by larger corporations, etc.? Does the government defend the original work at all, or are you at the mercy of who has the biggest lawyers, for instance? An example, maybe Tesla, Edison, Disney, China.
Well, one issue with patents for individual inventors or small companies is the government does not police your invention. Once you get a patent, you're required to police it yourself, and you need to go on your own after any potential infringer.
Another, for clarification, where do we file the patent application? I'm sorry if that was mentioned and it was missed, but just maybe to reiterate.
I didn't have that slide up there. You file your patent application with the U.S. Patent and Trademark Office. The website for that, you can file online and do everything online, is www.uspto.gov. But I do recommend you speak with a patent attorney if you're filing a patent application to prepare the proper patent application and prepare proper claims and make sure that you have all the requirements.
That was USPTO.gov.
Yes.
Okay, I'm able to put that in the chat.
It stands for United States Patent and Trademark Office.
Perfect. I have shared that in the chat. Another online question, what's the lean and smart way to do an FTO search? Can we use AI to do this work? What AI do you primarily use for searching?
I would always suggest that you use registered patent attorney or patent agent because they have access to numerous additional resources and also have the background to analyze the search. But you can get on the Patent Office website, the USPTO.gov. There are searching functions on there where you can search patents. You can also search on the internet, Google searching, things like that to see what might be out there. But for freedom to operate, you'd also, if you want to make sure that there are no patents out there that cover the invention, and you'd need to analyze the claims of that patent and make sure that you're not infringing those claims.
Well, thank you, Jack.
You're welcome. Thank
Very
you.
good. Now I'm going to invite our senior business counsel, Lita. She's going to present the services of the SBDC. All clients are welcome at the SBDC. If you have a question,
That's forward. That's back.
our services are free and confidential. I'm going to have Lita take it away now.
Good morning. My name is Lita Selmar, and I'm a business advisor at the Lower Hudson Valley Small Business Development Center. Who are we? We provide free, confidential business advising to support small businesses throughout their entire journey. We proudly serve the Lower Hudson Valley area, Rockland, Westchester, and Putnam County. Our commitment is to empower businesses to launch, grow, and strive while strengthening our local economy and building vibrant communities. Our services include startup guidance, turning ideas into sustainable businesses, business financing, loan packaging and funding assistance, business expansion, strategic planning for long-term growth, business planning, financial projections and market research, e-commerce and digital strategy, boosting your online presence, legal business structures, guidance on equity formation, operational efficiency, streamlining business processes, government contracting and bid matching, making sure that you can get good government contracting, and compliance and certifications. We empower entrepreneurs and strengthen communities. Personalized advising, tailored to your specific business goals, no cost, high value services, strategic plan of practical advice for all your business needs. We also offer free workshops, seminars, and classes like today, research driven insights to help businesses make informed business decisions. We strengthen our network, collaborate with our trusted partners, peer organizations, and leaders in our community. So sign up. All our business advisors are here to advise you in your startup or you would like to expand your businesses. Be on the lookout for our upcoming workshops. Thank you.